I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. A hearing was held earlier in the day in federal court in Washington, D.C., in connection with the new case filed by Special Counsel Jack Smith against Donald Trump for criminal conduct relating to the 2020 election. This was the first hearing after the arraignment was held on August 3rd. And this was the first hearing before the federal judge who will be presiding over the case, Judge Tanya Chutkan. This hearing was about the dueling protective orders that were filed, one by the Department of Justice. An alternative protective order was filed by Donald Trump's lawyers. Ultimately, the government wanted to ensure that Donald Trump cannot use the documents and other evidence produced in discovery to harass and intimidate witnesses, as Donald Trump has been doing. And Donald Trump's lawyers wanted to try to make accessible and available all of the documents and discovery so Donald Trump could precisely do just that and reveal the identities of witnesses and of documents that were obtained during the grand jury process, during the FBI witness interview process, and during other processes that led up to the ultimate indictment that was brought against Donald Trump. Judge Chutkan had some very harsh words for Donald Trump, gave warnings to Donald Trump's lawyers. I'll get to that in just one moment. But in terms of the protective order, Judge Chutkan adopted a bit of a compromise approach. The government wanted essentially all of the documents that they were going to be producing. And according to one of Jack Smith's lead lawyers who was at the hearing, Tom Wyndham, about 11.6 million pages of discovery and documents to be turned over. So not an insignificant amount of documents, but the government wanted all of those documents to be deemed sensitive information pursuant to a protective order so that they could not be made public presumptively. Trump's lawyers objected to that. On that one small, narrow point, Judge Chutkan actually did side with Trump's lawyers and said, no, it needs to be a little bit more narrowly tailored than that, government. Yes, witness interviews, grand jury material, other FBI investigation notes, addresses, and other personal identifying information. All of that can be basically deemed presumptively sensitive information and confidential pursuant to a protective order and not made public due to the threat of witness intimidation. But you got to be a little more narrowly tailored than that. But I think that was the only time the judge agreed with anything else that Donald Trump's lawyers were selling. And specifically, Judge Chutkan admonished Donald Trump's lawyers for trying to run a political campaign in her courtroom and made it very clear that the protective order that would be entered soon after this hearing had to be adhered to, and nothing in that gave Donald Trump a right to intimidate, harass, or threaten witnesses. And Judge Chutkan made it very clear that she would be running these proceedings as she would any criminal defendant. She said she doesn't care if there are political campaigns going on. That doesn't matter to her. She said that the government brought their case when the government's case was ready. Donald Trump is a criminal defendant, no different than any other criminal defendant that goes before our court, and he would be treated accordingly. Specifically, Chutkan admonished Trump's lawyer, John Lauro, who was there, saying that he was, quote, conflating what your client Donald Trump needs to do to defend himself and what your client wants to do politically. Your client's defense is supposed to happen, Mr. Lauro, in this courtroom and not on the internet. Federal Judge Chutkan also stated, quote, what the defendant Donald Trump is currently doing, the fact that he's running a political campaign, has to yield to the orderly administration of justice. If that means he can't say exactly what he wants to say about witnesses in this case, that is how it has to be. Mr. Trump, like every American, has a First Amendment right to free speech, but that right is not absolute. defendant's free speech is subject to the release conditions imposed at arraignment, and it must yield to the orderly administration of justice. And that's a significant line there by Judge Chutkan, because one of Donald Trump's entire defenses to the case brought against him, and this is why I said it was a frivolous defense, was basically he said he had a free speech right to engage in a conspiracy to try to overthrow the 2020 election, whether it's through the fake elector scheme, threats and intimidation, the various conduct he engaged in the various states with co-conspirators to try to change votes from Biden to Trump. There is not an absolute free speech right to engage in criminal conduct. When that speech becomes a criminal conspiracy, that is a crime, and that's actually what Donald Trump has been charged with here. The crime of conspiracy to overthrow our democracy, to overthrow a free and fair election. The same concept applies to discovery. In a criminal proceeding, there are protective orders. There are rules. You can't say that you have a free speech right as a criminal defendant to try to go against the orderly administration of justice and to violate the conditions imposed on your release. And Judge Chutkan made that very clear. Ben Meiselas here from the MeidasTouch network. You know, my old mattress was very low quality. It would overheat while my fiance and I were laying in it, making for a terrible night's sleep. Then I discovered 8 Sleep, spelled E-I-G-H-T, sleep. It's been transformative. You know, I didn't get much sleep already because of all the work that I do. And I always see in the comments, Ben, you need to get more rest. Well, with 8 Sleep, it's given me the rest that I finally need. It's truly been transformative. During the summer, while it's super hot, you know, I'm used to tossing and turning or sweating in the night when I do get some rest, but not with 8 Sleep. The pod cover by 8 Sleep is going to keep you cool all night, all the way down to 55 degrees Fahrenheit. So you're going to wake up fully refreshed the way I am right now. The pod cover by 8 Sleep fits any bed like a fitted sheet. And this pod cover, it's going to improve your sleep automatically by adjusting the temperature on each side of the bed based on your and your partner's individual needs. The first time I slept in an 8 Sleep and it brought the temperature down was like the greatest feeling I've ever had in my sleep period. And every night I look forward to 8 Sleep. I talk about this constantly with my brothers, with friends and family. I say, hey, you got to get this 8 Sleep thing. It is so, so great. So it definitely gets the Ben Meiselas personal endorsement. I can't say more positive things about this pod cover. It's going to cool you down if you want it to warm you up, and it's based on the phases of your sleep and the environment you're in. It adjusts for you. I love the temperature control and that both me and my fiance can set our side to each of our likings. I wake up feeling refreshed after a great night's sleep, allowing me to start the day off right. It's got great technology too. It's got this app that tracks your sleep. And when you wake up, you get your personalized sleep report. Look, I've never experienced sleep like this before. The pod's cooling technology is a lifesaver this summer. It's incredible. Here's what you got to do. Go to 8sleep.com/Meidas, EIGHTSLEEP.com/Meidas. Save $150 on the pod cover. It's the best offer you're going to find. Stay cool this summer with 8 Sleep. It's now shipping within the US, Canada, the UK, select countries in the EU, and Australia. That's 8sleep.com, EIGHTSLEEP.com/Meidas. You're going to love it. Judge Chutkan also concluded the hearing by saying the following, quote, I intend to ensure the orderly administration of justice in this case as I would with any other case. Even arguably ambiguous statements from parties or their counsel that can threaten the process. In addition, the more a party makes inflammatory statements about this case, which could taint the jury pool, the greater the urgency will be that we proceed to trial quickly. I will take whatever measures are necessary to safeguard the integrity of these proceedings. That's such an important line there from Judge Chutkan during the hearing, because Special Counsel Jack Smith has just filed a motion requesting a trial date be set on January 2nd, 2024. Donald Trump's lawyers are going to obviously object to that, and they're going to want a trial date sometime in 2025 or sometime after the 2024 election. Donald Trump has already made posts to that effect. And essentially here, what Judge Chutkan is telling all of the parties is that the more Donald Trump threatens people, the more he engages in witness intimidation, and that could impact the jury pool. From the perspective of this court, that will be one of the factors of why this case should go to trial immediately, to try to protect against the bias that the criminal defendant, in this case, Donald Trump, is trying to thrust on the voir dire process, on the jury pool. And so I think Judge Chutkan realizes that Donald Trump's not going to be able to control himself at all, that he is continuing to threaten people. She is aware, she's been provided with the material by Special Counsel Jack Smith's team, by Tom Winham and others, about Trump's threats of former Vice President Pence, Trump's threats about the prosecutor, the threats on the judge, and Judge Chutkan saying, well, the more he does that, that's going to make me more likely inclined to set a trial date in early 2024, even if there is a large amount of discovery in this case. So the next big hearing is set for August 28th. That is a trial setting conference there. She's expected to set the trial date. We'll see what Donald Trump files in his brief about the trial date. Again, we expect that to be requesting trial date after November 2024, sometime into 2025. And I do expect now Special Counsel Jack Smith's team at that oral argument to discuss all of the threats that Donald Trump has made. And I expect what they're going to do, we'll see if I'm right, they're going to make a grid and they're going to make a graph and they're going to show every single date, all of his threats. You're going to see 3 to 5, sometimes 10 threats a day if you add the interviews and events that Trump speaks at. So they'll show three threats, 5 threats, 10 threats, and they'll say, Judge, since the August 11th hearing that you held through August 28th, where you admonished Trump's lawyers, there have been 500 threats. I'm making that number up, but there have been 500 threats that Donald Trump has made against the court, against prosecutors, against witnesses. And if you go back even further, it's 1,000 or whatever the number's going to be. And Judge, that is why we also need to have the trial date, as you stated at the previous hearing. That's why we need this January 2nd, 2024 trial date. I thought it was very smart that Judge Chutkan did that as well. So we'll keep you up to date. Protective order is going to be entered. It's going to be somewhat of a compromise, more along the lines of what the government wanted, but just slightly more restrictive on the sensitive material. Government will turn over 11.5 million pages of documents to Trump's legal team, and the process will get rolling. I certainly expect there to be a lot of filings in this case, and we will keep you up to date. Check out MeidasTouch.com to get all the breaking news information. It's the one-stop shop for all things Meidas Touch, MeidasTouch.com. Thanks for watching, and make sure you subscribe to the Meidas Touch podcast as well. I'm Ben Meiselas. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.